Northside Development's entire purpose was to hold land in French's Forest outside Sydney. Two of the directors had little to do with the running of the corporation. The third director, Robert Sturgis, did all of that, which was really just paying the rates on the land and complying with corporations legislation. The company's constitution provided for a company seal, which could only be used after board authorisation, and the seal had to be signed by two directors, or a director and the company secretary. The company secretary was initially a solicitor, but when he resigned, Sturgis appointed his son. The appointment was not properly made, but the son began acting as the company secretary. Sturgis then went to Barclays Credit Corporation and secured a mortgage over the French's Forest land for $1.2 million. The money was to be paid to an entirely different company, which Sturgis controlled. The seal was affixed to the mortgage documents without board approval, and Sturgis Jr. signed as the company secretary. The loan was made, and eventually the other shareholders realised what had happened. They sued to recover title to the land. The question was whether Barclays was entitled to rely on the mortgage document. After all, from their perspective, this was a valid mortgage agreement bearing the company seal, signed by a director and the secretary. The indoor management rule said they didn't need to look at the company's internal process to find out if the board agreed. They had the seal. Chief Justice Mason said they could not rely on the mortgage. He said there was nothing on the face of the mortgage to indicate that it was unauthorised, except that it was given to secure an advance to a third party without any indication that the giving of the mortgage or the procuring of the advance was for the purposes of the appellant's business or related in any way to that business. That, in my opinion, is the decisive consideration. It requires the conclusion that Barclays was put upon inquiry. In other words, it was so unusual that a company would put up its land as security for a loan in favour of an entirely different company that Barclays should have seen red flags and should have taken steps to ensure that the mortgage was properly authorised. They did not, and so they could not rely on the indoor management rule to assist them.